Good morning, good morning. How is everybody today? I'm really honored that you all are here today and such a beautiful day. My goodness gracious. And you're in here talking to Mike and I about trusts. Holy cow. Well, welcome. How's everybody? Doing well? Yeah? How was your summers? Did you enjoy up north, those of you who were up north? Was it? Yeah, I heard it was cold and rainy. Is that right?
Not raining on the East Coast.
Not on the East Coast, but in the Midwest, right? The Midwest was pretty rainy. Yeah, I get to go up to Indianapolis, my hometown, in December to go visit one of my relatives. So, not the time of year I normally would want to go to Indianapolis, Indiana. So, today, and welcome to our annual maintenance program, we're going to talk about more specifics about protecting the inheritance that you all are leaving your loved ones. And there's two different types of trusts. Most of you have these elements built into your trust, but there's two different types of trusts we want to educate you about today. Mike and I will be talking about the difference between spendthrift trusts and discretionary trusts. Now, everybody has copies of the slides in case you can't see the board. By the way, you're going to be getting your maintenance packets in about a month or so. I authored a book. Here it is. Common Sense Estate Planning. It's on Amazon and Kindle, but each of you who are in the maintenance program will get a copy of the book in the mail with your maintenance program. So look for this. It's going to be coming in the mail. It's going to be in a box. And will I sign them? You really want me to sign it?
Bring it to the next workshop and he'll sign it.
I guess.
In February.
Thank you. So
we'll set up a little table and he'll sign it. He'll sign it all day long.
Yeah, how's that? I doubt I can. We have over 700 families in maintenance now, and I don't think I can sign all of those and personalize at least before I get these out, because it takes us. Dorothy, how long does it take us to get those maintenance packets out? About a week. It'd really slow it down if I had to sign everyone. But we're going to send you a book. I'll be happy to sign it, if you want to bring it to the next one or bring it by the office. And it's really a compilation of the articles that I write. Those of you who live on Sanibel, you may be familiar with my column that I write in the Island Sun. So we took about 100 or 120 of those articles, and I hired an editor, and she went through them and tried to categorize them into different chapters. So it's not really a how-to, or it's more of a chapter by chapter is its own independent topic. So you'll get one of those. So today, let's talk about why it's important to protect the inheritance. So who are we protecting the inheritance from is the big story. We're protecting it from creditors of your beneficiaries. Back when the mortgage crisis happened a few years ago, and a lot of my clients, a lot of your family members, maybe your kids, had homes that were upside down. And some of them lost their jobs and they got foreclosed. So let's say Johnny bought a house that was at $450,000 at the height of the market in 2007, and he has a big mortgage on it, and then he loses his job and he gets foreclosed. And then at the foreclosure sale, they sell the house for $200,000. And let's say there's a $400,000 mortgage. Well, the bank, it's not over. The bank has a deficiency judgment for $200,000 against the borrower. And that accrues interest until it's paid, or until the borrower declares bankruptcy or something like that. So there's a lot of your family members, I suspect, may have that type of problem. So when they get the inheritance, we don't want them to lose that to banks who may have judgments against them or other creditors. Predators, divorcing spouses we have to worry about. Those people who have large child support balances that they've never paid. You may have children who are in high-risk occupations, right? They might be doctors or lawyers or accountants or engineers who could get a malpractice claim against them, and the judgment might be in excess of their coverage. A lot of business owners have a lot of liability, don't they? Your family members who own businesses, they probably sign notes to vendors. They may have lines of credit with banks. And if their business goes south, oftentimes they're personally liable. There's also general liability. If your beneficiary should just accidentally hurt somebody in a car accident and they don't have sufficient automobile coverage or liability coverage. And then finally, we're going to talk about spendthrift beneficiaries, the ones that just spend too much. So the first thing that I want to go over is, are your revocable living trust assets protected? When you put your assets in your revocable trust, are they protected from your creditors? How many people say yes? How many people say no? Good. How many people don't want to answer because they're in a crowd and there's a lawyer sitting there watching what they're saying? Right? Actually, no. When you have your assets in your revocable trust, they're yours. It's under your Social Security number. You can do with them as you please, right? You can change your beneficiaries. You can put assets in. You can take assets out, right? So it's still your asset and still subject to claims of your creditors. Quick note, make sure you have enough umbrella coverage. Do most of you carry umbrella policies in excess of your automobile coverage? Please do that, because if you're in a bad accident, one of these guys on television, you know, the forthepeople.com guy, right? I mean, isn't the essence of his message, isn't there anyone we can sue for you? I mean, isn't that what they're saying? So you want to have sufficient coverage if you happen to be in a problem, even if it's not your fault. A lot of times they'll try to attribute it to you. So your trust assets are yours while you're alive. The trust is really you. But then at your death, what happens? The trust becomes something different, doesn't it? It's no longer revocable, it is now irrevocable, right? See, we do a good job with these guys.
Last 2 workshops, this is what this
I
is
know,
all
I
about.
mean, you know, you guys should be up here teaching us. So it becomes irrevocable, all right? But when you pass away and your assets go outright to your beneficiaries, when they go outright, what happens? It's owned by them, right? See, a lot of our clients will say, we don't need a continuing trust for Johnny or Janie. We don't need that, because when we die, they're just going to put the assets that we give them into their trust. But see, the only problem with that is that it's not protected. But you can protect it for them. And we're going to point out that a lot of you have already done that. A lot of you have continuing trusts for your children and other loved ones. So don't feel like, oh my gosh, I need to do that. A lot of you already have done it. But outright distributions, for those of you who have outright distributions to your beneficiaries, know this, it's not protected. It's not protected from all those horribles that I had up a couple slides ago. Now, inheritance, generally speaking, is a non-marital asset for purposes of divorce. Did you know that? Gifts and inheritance are, generally speaking, a non-marital asset for purposes of distribution in a divorce setting. So if you leave everything to Johnny and he gets divorced, his wife, Susie, is not supposed to be able to get to it. But what happens if on your death, Johnny inherits your assets and puts them in a joint account with Susie? Have we converted it now, the character of it, from a non-marital asset to a marital asset? You betcha. What if Johnny uses the money to pay off the mortgage on their house that they own jointly? Yeah, there's a number of ways that an outright distribution, even though it's supposed to be a non-marital asset in the event of divorce, could easily become a marital asset after the fact. So, with that, I always like to, once it gets real difficult, the topic, then I turn it over to Mike. So Mike's going to start talking about the difference between different types of continuing trusts.
Thanks, Craig. Hey, good morning, everybody. So yeah, again, like Craig said earlier, 2 basic types of these continuing trusts. The spendthrift trust, which I'll spend a couple minutes talking about, and then Craig's going to contrast that to what most of you already have, the discretionary trust. The spendthrift trust is really where we're trying to provide for the beneficiary, but at the same time making sure that they don't mess it up by collateralizing their inheritance or by borrowing against it or having it go to pay a creditor or a bill. So a typical spendthrift type provision is going to say no beneficiary may assign, that means transfer it, give it to somebody, anticipate, encumber, or alienate, that means borrow against their inheritance, or otherwise voluntarily transfer the income or principal of their trust share. In addition, neither the income nor the principal of a trust share created under this trust is subject to attachment, bankruptcies, proceedings, legal processes, interference from the control of creditors or others, or any other involuntary transfer. Now, who likes the sound of that? That sounds pretty good. It sounds kind of like what we want. Hey, we don't want the beneficiary to be able to assign it or to sell it or have it be otherwise encumbered or mortgaged or subject to creditors. And so we'll find that in a lot of trusts that we review. That's a standard spendthrift provision. There's a Florida statute on it that has very, very similar language. And it's all designed to make sure that the beneficiary doesn't mess something up. Here's the problem with your classic spendthrift provision, though, because and actually first, before we go to the problem, so some examples. So a beneficiary pledges their inheritance to secure a loan. So the beneficiary wants to, and this could happen while you're still alive. If I'm your child and I say, hey, I'm the beneficiary of mom and dad's trust, let me go borrow money to build my new house because when they die, I'm going to receive the inheritance, whatever that happens to be. So the spendthrift provision in each of your trusts prohibits your children or your trust beneficiaries from borrowing against that prematurely. Another example, a beneficiary assigns the inheritance to pay off a loan, kind of like what Craig was talking about earlier, where, hey, we're just going to assign it and pay off any mortgage or any loan that we have. The bank attempts to garnish an inheritance. That's another example. And then the three kind of big ones, the ex-spouse. The ex-spouse wants to garnish the trust for alimony, for child support, and then a judgment creditor, somebody that they owe money for that's already received, maybe they've been sued for any of the number of things that Craig mentioned earlier. They've been foreclosed upon or a lawsuit or creditor. So what is the Florida statute, which creates this spendthrift trust language, what does it say, and how effective is that language that we read earlier? Well, here's the problem. Under Florida, the classic spendthrift provision is unenforceable against certain types of creditors. We call these the exception creditors. And the exception creditors are your child. So if there's some type of claim for child support or for having to support, obligation of support of your child, from your spouse, from your former spouse who has a judgment for alimony, support or maintenance, from a judgment creditor who's received, who has provided services for protection of a beneficiary's interest in the trust, and from a claim of the United States, like the IRS. So what Florida has created is this really good, feel-good type of provision. Oh, spendthrift, I'll just add the spendthrift language. But what have they then also done? They've created the exception creditors that really we're mostly worried about, our spouses in a divorce context, and then foreclosure and other creditors. So the spendthrift language doesn't really get us a whole lot of benefit as to these creditors, or actually it says no benefit as to these creditors. And so that's where we came up with the discretionary trust and contrasting that to this discretionary trust, and can we get around these exception creditors is really the next issue.
Okay, so and all of you, by the way, when we do your trust, we have a spendthrift provision in your documents. So the spendthrift provision that you saw there is very similar to the one that you can find in your own document. Okay? So that means your kids can't pledge the inheritance before they receive it and those sorts of things. But when we go to try to protect the inheritance, when it takes the next step, what we typically provide is a discretionary trust inside of your trust. So it looks something like this. At my death, I'll use my kids, okay? And death of the survivor of my wife and I, we have 3 children, Gabrielle, Courtney, and Madison. Let's use Gabby as the example. So we have a trust created for Gabby's benefit. Now, typically, your child is their own trustee. So Gabby's her own trustee of this share, and it pays her income. She can pay herself income. She might be able to sprinkle it amongst her kids if she has any. She can withdraw a principal for health, education, maintenance, and support. Does that all sound familiar to many of you? Good. Now, what might be the problem, though, if Gabby's her own trustee and she has this discretionary trust? Well, she could spend it all. That's right. So if we're worried about Gabby spending it all, if we go back to, did you like my little slide? You like my little illustration? I had the lady with the shopping bags, but to show both sides of it, I had the young man with the Ferrari. What is that? Is that Lamborghini or Ferrari?
Ferrari.
It's a Ferrari. I'm not good with cars.
Very old Ferrari.
Yeah, I thought I was putting up a slide of some new car with the kid, and Mike tells me, Craig, that Ferrari's like how many years old? 10,
It's Magnum PI, so it's in the 80s. Isn't it?
Yeah.
So
I'm showing my age all the time now. So anyway, I was trying to show that's my.
my parents loved that show, by the way.
Oh, did they? Magnum PI? Thank you. So he's like an annoying little brother. So, that's my illustration of spendthrift beneficiaries. But anyway, so if Gabby's her own beneficiary, she might spend it all. But if I'm not really worried about that, I'm still worried about, let's say that she has a creditor, and the creditor goes to court, and the judge says, Gabby, we know this is a discretionary trust. Pay up. But you're the trustee. You have the power to invade. Pay up. What's to prevent that? Well, in our documents, what you have, if you look in your trustee section under Article 3, you'll see that if your child is acting as their own trustee and they have this situation, they have to appoint an independent trustee as their co-trustee at a minimum. So that's how we get around that problem. But a typical discretionary trust provision says, my independent trustee, that would be a co-trustee who you're appointing, may distribute to beneficiary as much of the income and principal of her trust as my independent trustee determines advisable for any purpose. And if no independent trustee is serving, my trustee shall distribute to the beneficiary as much of the income principal as the trustee determines is necessary advisable for health, education, maintenance, and support. You know why lawyers use those magic words, health, education, maintenance, and support? Do you remember why we did that? Want me to go through it? Okay. The reason is because there's an Internal Revenue Code section. If you care to look it up, it's in Internal Revenue Code section 2041. See, I haven't lost all my mind yet. But in any event, what that says is if a beneficiary is acting as their own trustee and the distribution is limited to what they call an ascertainable standard, and that's an ascertainable standard under the code, health, education, maintenance, and support, then it's not treated as theirs for estate tax purposes when they die. And that's what we want. Like when I leave Gabby all this inheritance, we don't want that to be added to hers for estate tax purposes. We want it to be outside of her estate. So to the extent that we do that, we have those magic words. But an independent trustee is not limited by that standard. It's only a trustee who is their own beneficiary. And by the way, there's a distinction between the creditor being able to go into the trust and grab the assets and a creditor who has to wait for the distribution. You understand the difference? So if the assets stay inside of the trust, it's one thing. So let's move on. Let's look at the difference between a spendthrift trust and a discretionary trust. Now, most discretionary trusts are also spendthrift trusts. We have that spendthrift language. All right, but not all spendthrift trusts are discretionary trusts. So this takes us to the Bacardi case. This was a 2006 case. And the facts of the case was the father established a spendthrift trust, not a discretionary trust, for his son. The son's ex-wife tried to garnish the distributions of the beneficial interest for alimony and child support. The Florida Supreme Court ruled that in certain limited circumstances, it actually said if this is the only way we can get the money, so it was a very limited circumstances, then the spendthrift trust distributions can be garnished. And the case talked about the distributions. So if you have a provision that you don't have to make the distribution, now it becomes, it's not just a spendthrift trust, what is it? It's a discretionary trust. Discretion to make the distributions. So the Bacardi case was generally bad for spendthrift trust because it said that these exception creditors, alimony, child support, they can go after these assets, but they can go after the distributions, not go inside the trust itself. So then the bright people on the Florida bar who sit on the committees decided to enact a new statute, which I cite there, 736-0504, and it provides that a creditor, including exception creditors, the ones that Mike had on the board just a moment ago, cannot compel a distribution that is subject to the trustee's discretion or attach or otherwise reach an interest if the interest is subject to the trustee's discretion. So you see how that works? The statute codified what the Florida Supreme Court was saying in the sense that they can't reach into the trust to grab the assets, they have to wait for a distribution. So if Gabby has a judgment creditor against her and she's inherited from my wife and I, and she is the discretionary trustee and she appoints somebody as her co-trustee as a discretionary trustee, what should she do? She should not make distributions to herself, should she? Not? Right? To
Right.
thwart the creditor.
Yeah, it's important to point out, not only can they not reach in to grab, they also can't force the trustee to distribute.
Right.
That's what Craig's going at there.
So now she can, if it's a sprinkle trust, meaning that Gabby can distribute not only to herself but to her kids, what could she do? She could distribute to her kids, right? That's okay. And that's not subject to the lawsuit. That's not subject to the creditor dispute. So she would, if you just hold your question at the end, then we'll take questions at the end. So that's how you thwart the creditor. Now, the problem is she can't really enjoy the inheritance, can she? Because she has to leave it in this trust and she can't make distributions. There's two problems with that. The first is trusts have a very, very high income tax rate. Once you accumulate income about over $11,900, you're in the highest marginal income tax bracket, 39.6%. A married couple doesn't get that high until they have $350,000 of taxable income. So that's problem number one. Plus you get 3.8% Obamacare, and if your child happens to live in a state that has a state income tax, you get the state income tax too. So there is a problem there with accumulating income and not distributing it. So that's
The flip side of that is I would rather pay 40, 50% income tax than 100% tax to a creditor, though.
Yes.
So,
And then what the strategy would be for the beneficiary would be to try to negotiate some kind of a settlement, saying, look, I'm not going to make distributions. You can wait here for 20 years and negotiate a settlement. But see, if it's an outright distribution, do they have that option? If you have an outright distribution in your trust? No, because it's theirs and now the creditor can go get it. So the discretionary trust gives them some power. So the Bacardi court indicated that the discretionary trust could be at risk, and it was unclear whether the statute that was enacted is meant to thwart the court's opinion. So here's the language from the Supreme Court, the Florida Supreme Court in Bacardi. We further limit this right of garnishment to disbursements that are due to be made or which are actually made from the trust. Okay, so if the trust calls for an automatic distribution of income, even if Gabby doesn't make it to herself, it could still be lost. That's why discretionary trusts usually are full discretion for both income and principal. If disbursements are wholly within the trustee's discretion, the court may not order the trustee to make such disbursements. However, if the trustee exercises its discretion in making the disbursement may be subject to the writ of garnishment. So y'all follow that?
go through it
Law
one more
School
time.
101?
Yeah, go through it one more time.
Okay, so what it says basically is, this is what the court's saying. The court says the creditor can only take those assets that are either actually being distributed from the trust or are scheduled to be distributed from the trust. Okay, so let me give you an example. Let's say your trust says, it's not a fully discretionary trust. It says at age 30, my beneficiary gets a third of what's in the trust. At age 35, they get half of what's left, and at age 40, they get everything else. Okay, that's a tiered distribution. All right? So if your trust says that, and the beneficiary is 36 years old, and they haven't made the 35 distribution, where they could make the second third of the distribution at age 35. They've left it in trust to try to thwart the creditor. Have they done so?
Because it's scheduled to be.
That's right. They have not done so because they were entitled to the amount at age 35. They just chose to leave it in the trust. So the language of the trust is really important. Now, most of the time when Mike and I draft them, the discretionary trusts are fully discretionary. So if you have a discretionary trust in your documents, don't worry, it's already there that way. So now I'll turn over to Mike. I'll set the stage for you. So far, we've just been talking about assets inside your trust. A lot of you, though, a significant portion of your net worth is what? In assets and IRA accounts, 401k accounts, and all those sorts of things? Are those in your trust? Generally speaking, no, they're not. What governs those? Beneficiary designations. All right, good. Now I'll set it up and give it to Mike.
Very good, very good. So, like Craig said, the big asset that, well, we got a couple different types of assets that generally aren't in your trust. IRAs, 401ks, annuities, life insurance, all these assets that name their own beneficiaries. Now, life insurance and annuities a lot of times can funnel through your revocable trust and can still piggyback on those trust provisions. IRAs are treated very, very differently. We don't funnel those through the revocable trust, and we can't piggyback on those. So let's kind of take a look at how we do this planning for IRA assets. First off, unlike your revocable trust assets, are your IRA assets protected from your creditors? Show of hands how many think your IRA is protected for you. Show of hands how many think that's exposed to your creditors. Again, who doesn't want to answer? All right. Well, excellent. Well, Florida statute's right on point here. Florida statute 222.21, any money or other assets payable to a participant, you, or beneficiary, you, in a qualified retirement or profit sharing plan, this would be an IRA or a 401k, is exempt from all claims from creditors of the beneficiary participant. So based on that, who thinks they're protected? The IRAs and 401ks are protected. All hands go up. Yes, they are protected for you. So your IRA, your 401k are protected under Florida statute. That is a Florida-specific rule, by the way, for IRAs. Not all states protect IRAs for the participant, for the beneficiary. Now, one thing to point out, though, this word beneficiary in the statute is not your kids. We're not talking about your named beneficiaries after you pass away. So it's an important distinction to realize. It's talking about you while you're still alive and while it's still your IRA. And basically the policy is we want to make sure that you're not left destitute and dependent on the state. You still have your retirement account, and some creditor can't take it all away from you, and you still have something to live off of when you retire. So that's what happens for you while you're alive. Now, what about inherited IRA accounts? We talk a lot about IRAs and inherited IRAs and the beneficiary designation, and we focus mostly on the income tax planning. Your custodian or your broker might say, yeah, we'll name the kids as the beneficiary. They'll be able to stretch out the income and not pay all the income tax. And that's all well and good. And we do that inside of an inherited IRA account. So they don't have to take out and pay all the income tax immediately when you pass away. But what about all these creditor issues that we've talked about? The spendthrift and the child support or the alimony or the equitable distribution. Well, there's been a recent case that's come out on that. I don't know how you pronounce that. Ramaker. It's specific, and we always wondered this. I had my suspicions, but we always wondered this. And this U.S. Supreme Court case said, under the current law, is inherited IRAs are not protected in the hands of the children because it wasn't their plan. It wasn't their retirement account. They inherited it, and the only reason that they have it in this inherited IRA account is just to save income taxes. And so what the Ramaker case would allow is a creditor to say, okay, beneficiary, you can take all of this money out of the IRA. Yeah, you got to pay income tax, so do your withholding or whatever, but give us the net. So inherited IRAs, although are somewhat protected for income tax where we can stretch it out, they're completely exposed to the beneficiary's creditors. Okay. Also, a couple other things just to point out about inherited IRA accounts. They cannot just take these inherited IRA accounts and add it to their own personal IRA. Remember, under Florida law at least, the children I'm talking about, their personal IRA is protected from their creditors. And when they receive the inherited IRA, they can't just add it in the pot. It's got to be separate and distinct. They also can't add to that inherited IRA account. They have to add to their own IRA account as they're getting their income. They can withdraw the entire amount penalty-free out of an inherited IRA account. That's nice. So if I'm a beneficiary and I've got my personal IRA, and if I'm under 59 and a half, there's a big penalty, a 10% penalty. But I can take it all out of an inherited IRA account. And they also have to withdraw out annually. So just a couple little things about inherited IRA accounts. They have to take it out starting the year after you pass away. They have to start taking out their minimum required distribution. So Craig's going to talk about how do we get around this and what do we do to solve this issue.
Why don't you stay up here with me?
Yeah, sure.
Before we get to this slide, let me just back up to that minimum distribution thing that Mike was talking about. When does your minimum distribution start? 70 and a half. You must start taking required minimum distributions, right? When do your beneficiaries' minimum distributions start when you die and you leave them the inherited IRA? Right away, the next year. That's right. That's right. Mike mentioned that. So what the Supreme Court said, in essence, was when they were trying to distinguish between a discretionary trust, for example, that's protected and an inherited IRA that's not, what they said is, remember when I said if Gabby can get to all the income or if it's an outright distribution, it's subject to her creditors? Well, the Supreme Court essentially said the same thing in Remacher. What it said is, look, the beneficiary has a right to withdraw all of that inherited IRA right now. Right. And because they have that right, it's subject to the claims of their creditors. Do you see how the logic follows? See, lawyers are actually logical. Do you believe that?
Very logical.
Okay, they're not buying it.
IRS might not be logical.
No, the IRS may not be logical.
I think we're logical.
So now we're going to talk about potential solutions. Mike, why don't you go through the continuing trust share and that diagram? Yeah,
well, basically, like we've alluded to, a lot of you already have this, and instead of just giving it to them outright, and I'm talking about the beneficiaries, instead of just leaving it to the children outright, free of trust, no strings attached, we create this continuing trust. And many times, the child's their own trustee. They're the primary beneficiary. They're not the only beneficiary usually. Craig said the word sprinkle trust a little while ago, where we've got their kids, the grandkids, as kind of permissible beneficiaries. And they also have what we call usually what's called a special power of appointment, which lets them say who the beneficiaries are when they pass away. So we've given them full control. They're in charge. They're the beneficiary. They're deciding the investments. They can say where it goes when they pass away. We pulled just enough strings, though, that it's in trust. And if they get sued, if they get divorced, if they have a creditor problem, the argument is, no, this is an indiscretionary trust, and my creditors, even my exception creditors, shouldn't be able to get to it. Okay, so we hold that in trust. That's all built right into your revocable living trust, and then that's where it sits. It sits there for really the rest of the child's lifetime, and they're investing it just as they would. They just have two separate accounts. They have their own personal funds, and then they've got mama or daddy's trust that was created for them, and they just go through life that way. And then when they pass away, again, the trust is going to say where it goes, and usually it drops down into continuing trust for the grandchildren on throughout until there's no money left over.
All right, so then I'm going to take the inherited IRA issue. Some of you have retirement plan trusts, right? Some of you have retirement plan trusts, and here's, just refresher, here's how they work. So you have the inherited IRA, that's the pink box at the top. So you pass away and leave it to one of your kids or somebody. It's an inherit. Now, by the way, if you leave it to your spouse, what's your spouse do with it, typically? Spend it. No, that's my spouse. What does your spouse do? No.
Hopefully her spouse isn't here.
No, Patty knows. Anyway, she's put up with me for 25 years now. Anyway, the spouse will roll it over, right? Into his or her own IRA.
And it'll become their IRA.
Yeah, and then they name beneficiaries. Right. Does that make sense to everybody? Okay, but when you leave it to your kids or other loved ones, the pink box is the inherited IRA, right? And the blue box is the retirement plan trust that we have in between, with the trustee. And you see the thinker there, and you'll see the words required minimum distribution. If you can't see it on the screen, look on your sheets that we handed out. So we have required, so remember that your children have required minimum distributions every year, right? But it's still discretionary because what? The trustee can withdraw more than that if they need to, right? So if Gabby's required minimum distribution this year is $5,000, but she needs 15 to pay for her kid's college education, she can take out the extra, right? So the first layer of discretion is how much beyond the required minimum distribution is withdrawn. Then the next layer of discretion is whether it's accumulated inside the retirement plan trust itself or distributed out to the beneficiary directly as like what we call a conduit trust. You know, take the money out of the IRA, don't keep it in the trust, but then just distribute it right through to the beneficiary, just all the way through. So the trust is really there only as like a safety valve, right? If the beneficiary is in creditor problems or has litigation problems or is getting a divorce or they're worried about something that has to do with someone trying to take that IRA, they can convert that retirement plan trust into a discretionary trust. And there's technical rules about when and how that happens that we're not going to talk about today. But
we have the opportunity to stop it, basically. The minimum required distribution has to come out, not stopping that. If we don't, we got a big, huge penalty for failure to do that. But we can stop it at that trust level, at that trust layer.
you know when you take your garden hose, you turn it on, and then you kind of cinch it somewhere just to stop the water flow from going out? That's essentially what the retirement plan trust is doing. It's cinching the money inside the trust as opposed to distributing out, because we have to make the required minimum distribution anyway.
Yeah.
See how that works? Does that make sense? Yeah? No? Do we thoroughly confuse you? All right. Now that we've thoroughly confused you, we'll open the floor up to questions. Yeah. You want to take that, Mike?
Yeah, the
Repeat
question was,
question.
what's the income tax or the tax consequences to the beneficiaries when they take it out of the IRA into the continuing trust? And the way we draft the retirement plan trust, the IRA trust, is it's what we call a look-through trust, or a look-through trust, I guess that's what it's called under the code, where we can piggyback on the beneficiary and use the beneficiary's life expectancy, so they're taking out on their life expectancy. And it's really the same tax consequences as if they were named as the beneficiary individually, if, like Craig mentioned earlier, it just conduits through. So let's say I'm entitled to a $10,000 minimum required distribution, and I've got this trust. So in this year, I'm going to take that $10,000 out of the inherited IRA, put it into the trust, because that's where it has to go, and then I'm immediately going to turn around and distribute it out to me personally as an individual. And I'm going to claim that $10,000 as taxable income for this year. Same as I would have had the IRA trust not been there, right? It's just going to flow right through.
Bill?
Husband and wife each have an IRA. Husband dies. Wife takes husband's IRA and rolls it over into her.
Yeah.
The entire wife's IRA is exempt from claims of creditors.
From her creditors, yeah. Yeah, the question was, if we have husband and wife, and actually this is a good point, because I wanted to come back to the rollover. The specific question was, if husband and wife, husband dies, roll it over, it becomes the wife's IRA at that point. The Florida statute that I cited applies. She didn't have to be the one to contribute, which is kind of the heart of your question. It's her IRA. Now, one of the things that we do is, if we have a husband and wife, we create an IRA trust for both spouses, even though husband might be the one with the 401k or with the IRA. And the reason that we create one, go ahead and create one for each one of you, is because if husband dies first, guess who's got the big IRA and the big 401k at that point? The wife, because she's just going to roll it over, and now it's going to be her big IRA or big 401k. We don't want to have to go back and remember to create another trust if the husband passes away first. So we go ahead and build it, and we have the trust. Now, the only thing we got to make sure of is that we do a new beneficiary designation for the wife when she inherits it and makes sure, or when she receives it and rolls it over and make sure that it goes through her IRA trust at that point. But yeah, that's the way it works.
The discretionary trust builds a wall between the beneficiary and the creditor. How likely is it that a creditor with deep pockets can overwhelm that protection?
Yeah, the question is, the discretionary trust builds a wall. How thin or thick is that wall to the creditor? Can they pierce the veil, so to speak? Well, let me give you another example. There was the Lerner case not too long ago. Let me describe the facts of that case. Mom lived in Fort Lauderdale and set up a trust for her son who lived in D.C., I believe it was. Virginia or D.C., one of those jurisdictions. No, it was New Jersey, excuse me. It was in New Jersey. Son, and this is important. Son lived in New Jersey. Son was divorced and he had like $300,000 of alimony back payments that he hadn't made and about $100 and some odd thousand of child support payments he had made. So he was kind of a renegade. Son flew out to California and was living in friends' garages trying to evade the New Jersey authorities. Mm-hmm. They eventually found him and jailed him. Mom had died with a discretionary trust for son, Florida Trust, okay, with uncle, her brother, son's uncle, as trustee. The New Jersey Supreme Court said, it eventually went all the way up the line, and the New Jersey Supreme Court said, this is a Florida issue. It's not a New Jersey issue. We have to release son from jail. Because the Florida Supreme Court said, as bad of the outcome as we don't like this outcome. We think son's terrible. He should be paying his ex-wife. He should be making the child support payments. It is a discretionary trust, and we can't invade it. So if this guy who's running around living in friends' garages with $400,000 of back alimony and child support gets rid of, it seems like it's pretty good law. And that case was back from after Bacardi and after the new statute. So, one never knows. You might get a sympathetic court that decides to figure out a way to invade. But these discretionary trusts are pretty powerful, I think. Yes?
You're making a CD of this,
Yeah, we're making a DVD of this.
send one to each of us?
Yeah, all y'all gonna get one. You'll see our bright, shiny, that's why I dressed up in a suit. So you guys usually see me, I'm not in a suit. I had to dress up, put on my makeup this morning. My wife did my mascara, the whole thing.
You told us very informative, very interesting, we'll probably remember that.
Yeah, well, you don't have to remember all this. What we're trying to do is educate you so you know what many of you have already done.
Yeah, and as to that, and our nomenclature has changed a little bit, but the B or the C plan, the enhanced or the enhanced plus plan, if those mean anything to you when we were kind of initially going through, that's what these are. So when we're talking about providing protection for the kids, this is not just the outright distribution. This is not, Craig mentioned earlier, kind of the tiered trust. I call it a stage trust. If you look at your trust and there's an outright distribution at 35 or 30 or whatever, that isn't this. And so...
Yeah, and the other thing we do with this, by the way, is I just had a case where one of our clients, his son was in a divorce situation, and they were trying to get to the inheritance. And I forwarded to the divorce attorney in New Jersey, as it turns out, copies of all of this with the case law that we have, and apparently she was successful in warding off that claim. So another reason we do these videos too is for other lawyers, and we give them all this material too. So if your kid's ever in a situation, we have the materials ready to give to their lawyers to fight the fight. Yes?
In that example you gave earlier, that you order a discretionary trust where there was a creditor that was trying to get a judgment.
Right.
And you said that she doesn't have to take the money out of the trust. Can she take it out for those four exceptions, health, maintenance?
Okay, the question is, when I gave the example of my daughter Gabby, and she has a creditor after her, and I said don't take don't make a distribution out of the trust. What the question is if she made the distribution for one of the exceptions, health, education, maintenance, and support, would it then be protected? Am I paraphrasing your question correctly? The answer is it's not protected. The distribution, once what the case law says and what the statutes read, once it gets, it's kind of like toothpaste in a tube. You ever try to put toothpaste back in the tube? Right? You can't put the toothpaste back in the tube. Once you squeeze that tube and it's out, it's out. And once it's out, now it's subject to claims of these creditors. So
in your case, Gabby would want to make sure that she distributes to one of the other beneficiaries that might be named if she had kids and
yeah, she could distribute to her kids if they're not parties to the lawsuit. Yeah.
Going back to the original trust, my husband and I each have it. Now, I see a lot of older people being moved out of state for health reasons.
Mm-hmm.
They're ill. What happens then? Do they
You want to take that one?
all still-
Yeah, the question was what happens as maybe you get a little bit older, maybe you lose one of your spouses, or your spouse, not one of your spouses, you lose your spouse. That'd be interesting. You lose your spouse, and we're laughing about this. You lose your spouse, and maybe you move back home to go closer, to live closer to the kids. What happens to your trust at that point? And we've got some options. It kind of depends on the circumstances and what you're going back for. Sometimes we can keep the trust as a Florida trust, and still maintain it under our maintenance program and still make sure it stays up to date. But we would definitely want to get the involvement of the back home attorney to at least review the wills and the powers of attorney and kind of the ancillary documents. Or the other alternative is just complete transition to a new attorney if you're comfortable with that.
In the new jurisdiction.
Yeah,
Yeah.
in that particular state. So we kind of talk to our clients and have that conversation. Usually, though, when we weigh kind of the tax implications, a lot of times we try to find a way to maintain Florida residency somehow, some way, and that wouldn't change anything. So,
Yeah, one of the issues is the state that you're moving to have the same or better law than what we may have. Florida, generally speaking, is a very good state for asset protection and for credit. Like that IRA, the statute that Mike talked about with your IRA, that's not present in all states.
most states.
In most states, in fact. Yeah, Florida's unique in that we protect things. Your life insurance, your cash buildup of your life insurance is part of that same statute. Creditors can't get to it. In other states, they can. So if you have dual if you have another residence in some other state and you're considering making that your permanent state again, after moving here, you might want to have these conversations before you do so. Anything else? No? Well, thank you all we'll stick around here. Thank you all for spending your valuable time with us today.
Thanks, guys.
We appreciate it.